Does the keyboard work? That's what I'm Okay, Franklin is here.
All right. Olga, can you mute your thing for a minute?
Say that again?
Mute your thing.
Can you hear us?
Yeah, mute yourself.
Okay, sorry.
Court is now in session. The Honorable Judge Denis Cohen presiding.
Good afternoon, everybody. Good to see you all. Ben, would you call the first case, please?
Sure. Now calling case number 2102-00383, Reynolds et al. V. Hightower et al. Would counsel please introduce themselves for the record?
Yes, this is Ryan Anderson on behalf of the plaintiff,
And
Reynolds.
the court would also ask that anyone who's not here in this case, that they can turn off the video and mute themselves and just come back on the screen when their case is called. Okay, Mr. Anderson?
Yes, this is a case where defense counsel's already tendered their policy. We have things set up to split up what was a 1530 policy. They tendered their policy to us. We've been working to deal with everything that has to be done to get the orphans court to sign off because our client's deceased. So we've got everything except for the letter from DHS saying that they have no lien against anything on this. We were here about 45 days ago. I wish that it was done now. We do have the Pennsylvania Department of Revenue who has signed off that the distribution is proper, but we just do not have DHS yet.
Okay, and how much time, Mr. Anderson, would you need?
If I could have 60 days, I very much hope that it will be done. I can't guarantee, but that should be a good allotment of time.
Okay, so for the record, this is a rule returnable that says, and now this first day of November 2022, plaintiffs having failed to appear, and now this 14th day of September 2022, the rule returnable issued upon plaintiff to show cause why the matter should not be non-process for failure to file a complaint that was scheduled for Wednesday, September 14th, was continued till today,
Right.
November 9th at 2 o'clock. So, Ben, can you tell us 2 months from today or 60
Right.
days from today, what would be a Wednesday we should schedule this for?
Let me look, Judge. So that'd be, I believe that'd be January 4th. Yes, Judge, January 4th.
Does that work for you, or do you need a later date?
No, that's fine. I hope to have it done long before that. They have everything. I can't say that any more time would make this go any quicker.
Okay, so we'll continue this to January the 4th. And we'll issue a new rule returnable that says the same as this one does, that essentially that plans to show cause why the matter should not be non-process, etc. Hopefully by that time, Mr. Anderson, everything would have gone through. Court understands there are a number of items that you simply just can't control.
Thank you, Your Honor. And hopefully I have an OSD filed before that, hopefully before the holidays. Thank you.
Okay, that sounds great. Thank you for all your work on this, Mr. Anderson. The court appreciates it.
Thank you.
Okay, thank you. And so again, we'll issue a new rule returnable.
All right, may I be excused?
Yes, you may be excused. Thank you.
All right, thank you.
Next call, Judge, are you ready?
Yes.
Next case. Okay, now calling the next case, case number 2105026669, Mustafa V. Brown et al.
Okay, and
Counsel, would you
Your
please,
Honor. Nick Lyons
counsel, would
for
you
the
please
Commonwealth,
introduce
Judge. How are
yourself for
you?
the record?
of course, sorry, my law clerk and Mr. Lyons were speaking at the same time. So, Mr. Lyons, what my law clerk said is, will you please introduce yourself for the record?
My apologies. Nick Lyons on behalf of the Commonwealth.
Okay. Now, this is the case of Mustafa. This is case number 2105-02669. Mustafa, Mostafa versus Brown versus Commonwealth of Pennsylvania Department of Transportation. And Mr. Lyons, you represent the Commonwealth Department of Transportation, correct?
That's correct, Your Honor.
Okay. So this is a rule to show cause that says plaintiff having failed to appear for the mandatory pretrial conference, rules hereby issued upon Ahmed Mustafa to show cause why the above captioned matter should not be non-pros for failure to prosecute. The rules returnable today in Zoom at 2:00 in Zoom virtual courtroom 480 before this court. And it is now 2:12 p.m. Mr. Mustafa, Ben, has Mr. Mustafa checked in?
He has not, Your Honor, and I do not see anyone by that name in the Zoom courtroom.
Okay. And Mr. Lyons, during the course of this case, has Mr. Mustafa, after the filing of this matter, participated at all?
He has not, since I've been a part of this case, Judge, and he did not file anything with respect to the pretrial conference. He has not retained counsel after his counsel was removed.
And when do you recall when his counsel was removed?
I
When
can tell
counsel
you.
was through?
I can tell you in 1 second, Your Honor. Looks like April 29th of this year, Your Honor.
Okay, thank you. And had there been a settlement conference on this case?
No.
Okay. Okay, so Mr. Mustafa is not present. He was not at the pretrial conference, as Mr. Lyons mentioned, and that's why we set up this rule. And the court also understood from Mr. Lyons before that after counsel withdrew, Mr. Mustafa did not participate at all. So the court will find that that he isn't here today, wasn't at the pretrial conference. The court will non-prosecute the matter for failure to prosecute. Thank you, Mr. Lyons.
Thank you, Your Honor. May I be excused?
Yes, you may be excused.
Have a great day.
Thanks, you too. So Ben, if you can enter the non-pros.
Yes, Judge. Sounds good.
Okay.
Are you ready for the next case,
matter?
Judge?
Yes.
Yes, now calling case number 210602620, which is Sherwood v. State Farm Mutual Automobile Insurance. Counsel, will you please introduce yourself for the record?
Yes, this is Deepak Sharma for the plaintiff, Riley Sherwood.
Good afternoon, Your Honor. Lauren Glenn on behalf of the defendant, State Farm.
Okay, Mr. Sharma and Ms. Glenn, good afternoon.
Good afternoon.
Good afternoon.
So this is a rule returnable that says now this 18th day of August 2022, the rule returnable issued upon plaintiff to show cause why the matter should not be non-pros for failure to file a complaint scheduled for Wednesday, August 17th is hereby continued to November 9th at 2:00. Mr. Sharma, you represent plaintiff?
Yes, Your Honor, and I'm proud to report that we finally have some progress. So the tort action that has been pending in Virginia has finally settled. So the tortfeasor's carrier has tendered the policy limits, and I believe that the matter is now ripe for UIM to proceed. And I was emailing with Miss Glynn earlier today, and I gave her my client's settlement demands. And I don't know if it might be beneficial to give us some time to talk about settling, or if you want me to file a complaint now, I'm happy to do so, Your Honor.
Well, let's hear from Ms. Glenn.
Good afternoon, Your Honor.
Because Because if Miss Glenn is going to tell the court, Mr. Sharma, that she's about to settle the case, then it just seems silly to have everyone go through all that additional work and time and expense. So, but let's hear what Ms. Glenn says.
Good afternoon again, Your Honor. So I did
Yep.
receive counsel's settlement demand this afternoon. I certainly don't have any authority to settle right now, and it is rather a large demand given the treatment that's been incurred. I'm hopeful that we will be able to resolve it, but I can't predict the future. But I certainly wouldn't want Mr. Sharma to go to any unnecessary work or expense if this is going to resolve. So I've never requested to enforce my rule at this point, so I would just defer to Your Honor, and I certainly don't. I'm not making a request that you have to file a complaint right
And
now.
I would say, Your Honor, that I think I would ask for an opportunity for us to talk, because that was just the first number that we communicated. And that's not the bottom line necessarily.
So, how much time would you need to try to wrap this up? Because the court appreciates that Ms. Glenn is not asking for the court to enforce the rule, but the court, as the judicial system, wants to keep the cases moving. So, generally speaking, we like people to file a complaint, but if there's a possibility of wrapping it up in a short amount of time, then there's no reason to do that.
May I make a suggestion, Judge?
So, absolutely, Mr. Sharma.
So I heard earlier that you had given somebody a deadline of January 6th. So I think
Those were different circumstances.
Yeah, I understand that, but what I'm saying is that I think that if this case is going to resolve, then it's going to happen before the end of this calendar year, and if not, then if we're going into January, then we'd probably be ready to file.
So in that case, it was 60 days because they're waiting for orphans court to rule. They're waiting to hear back from one of the agencies about what type of lien. Here, we're just negotiating with counsel, and obviously counsel will then be talking to a client. So it's not
True.
It's not outside the party's control.
Absolutely.
Whereas the other one was, and they were all set to settle. They just needed the third parties to come along.
Understood, Your Honor. I'm not trying to equate the situations. I was just saying that might be a good date to say, like, okay, if we're not settled, then I'll go ahead and file, because I also don't want to. I want to move this thing forward if it's not going to resolve by the end of this year.
But wouldn't this be something that we know within 30 days? Because you're not talking about any discovery between now and then. It's a simple negotiation.
Yeah, I would just want an opportunity to send some HIPAAs out if I need to get some updated records that I would have to submit to counsel. I can always file my complaint before, but I'll leave it up to you, Judge. Whenever you want me to file, we'll do that.
Okay. If you need to have records, then we should definitely have you file a complaint. We should go through that if you're going to wind up having to get records to turn over.
Well, I've submitted a package to State Farm, but they might need some recent chiropractic records. That's the only thing that they might not have right now.
Okay, and Ms. Glenn, you're not sure what records at this point. You're not sure what records you may need because you just received the demand.
So yes, I did. So counsel did provide extensive treatment records about a year ago or so at the start of this case to State Farm, which I do have. This entire time I was waiting on the third party settlement, and now I received the demand that I was waiting on. And so I have provided the demand to my carrier already. I anticipate being able to have a response within 30 days. I don't know that it would be necessarily a settlement at that point, but I do anticipate within 30 days having an offer that I could make. Again, this is just the first time that I actually have a point of reference as to where settlement stands for plaintiff.
Okay, so the court will give 60 days, but this is the final continuance for that. If it's not resolved in 60 days, then you must file a complaint, otherwise the court's going to non-prosecute the case.
Yeah, and Judge, I very well may file in advance of that deadline. But I just want an opportunity to speak with counsel.
The court understands that. So what we'll do is we'll issue a new rule returnable for January 4th. Does that work?
Sure.
That's
Okay,
good.
that'd be, and so Ben will issue a new rule returnable with basically the same language as in the current rule returnable. The only thing is we're going to say it's going to be continued to January the 4th.
Just sounds good, Judge. Just to clarify, that's slightly under 60 days, but if January 4th works,
Well, let's make it January 11th.
sounds good.
Okay.
Thank you very much, Judge.
Okay. Thank you. Good luck in settling the case.
Thank you, Your Honor. May
And
I excuse-
obviously, Ms. Quinn, you can advise your carrier that Mr. Sharp, if it doesn't resolve, he's going to file a complaint, and there are going to be a lot more costs.
Sure, of course.
So the carrier gets to save all those extra costs. Of course, there are other issues, but we won't get into that on the record. Anyway, good luck in getting the matter resolved, and we'll see you back on January 4th. Hopefully, you'll both report that the matter's been settled and you moved on to all the other millions of other cases that each of you have.
Thank you, Your Honor.
Okay. Thank you very much. Appreciate it.
Thank you.
I'm going to sign off if that's okay, Your Honor.
Absolutely. Thank you.
May I
Thank
be
you, Ms.
excused,
Quinn.
Judge?
Yes,
Thank
you may
you.
be excused.
Thank you.
Next calling, case number 2103-02679, Rodriguez Cruz et al. Versus Republic Service, and the rest of the name is cut off on my sheet. Counsel,
Okay,
would you please
so-
introduce yourself for the record?
Good afternoon, Your Honor. My name is Jared Teich, and I represent the plaintiffs in this matter.
Mr. Teich, how are you?
Very well. How are you?
Good.
And my client is also on the Zoom with a Spanish interpreter from my office.
Okay, great. Thank you.
Good afternoon,
So,
Your Honor.
Mr.
Ed
Brandenstein?
Brandenstein. I represent the defendants.
Yes,
We're
Mr.
just
Brandenstein.
just
How
here
are you today?
observing. Oh, wonderful, Your Honor. Yourself?
Very good. So, Ben, if you can swear in the plaintiff and make sure the
Do I need to
plaintiff
swear
states-
in the interpreter first,
Yeah,
Judge?
swear in the court. Yeah, swear in the court interpreter, and then swear in the plaintiff, and make sure each gives their full name, first name. They spell their first name and last name for the record.
Sounds good.
Okay, Ben, go ahead.
Would the interpreter please raise your right hand? Do you swear and affirm that you will translate the Spanish language to the English language and the English language to the Spanish language to the best of your ability?
I do.
And please state your name and spell it out for the record, please.
Olga Negron, Olganegron.
And Danielle, did you hear all that?
I got it, Judge. Thank you.
Okay, great, thank you. Go ahead,
And
Ben.
now would the client plaintiff please raise his right hand?
Levanta su mano derecha, por favor, que la vea el juez.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
¿Usted promete decir la verdad, solamente la verdad? Sí. Yes.
Would you please state your full name for the record and please spell it out?
¿Puede por favor decir su nombre completo y deletrearlo?
Franklin Rodriguez Cruz.
Franklin Rodriguez Cruz, and that is Franklin. Rodriguez, Rodriguez, and Cruz, Cruz.
Okay, thank you.
Gracias.
Okay, so this is a rule returnable that was issued the 3rd day of November, 2022, upon consideration of the motion of attorneys Charles J. Schleifer and Jared M. Teich to withdraw as counsel for plaintiffs Franklin Rodriguez Cruz and Jolie Mata Acosta, rule returnable is hereby issued. The show cause why said motion should not be granted. The rule is returnable today at 2 o'clock in Zoom virtual courtroom 480. So, Mr. Tyke, let the court ask you a question. Does your client, do your clients, you represent both, is that correct?
Correct.
Do both your clients know you've moved to withdraw?
Yes, they do.
And how have you been in touch with your client? With your clients?
By telephone, and we have a bilingual staff that communicates any and all conversations I have with him.
Okay, and what is their position as to your motion to withdraw?
In all honesty, Your Honor, I'm not quite sure. We've had just a breakdown in the attorney-client relationship. There was a time back in August where plaintiffs requested to find their own new attorney, which we welcomed and sent a letter just advising of the court deadlines. I made him aware of this. We've had many conversations about defendants' offers to try to resolve this case, and there's just a clear either lack of trust or there's a big disconnect in the attorney-client relationship that has made me uncomfortable moving forward representing the plaintiffs.
Okay, and that's the reason for withdrawing? Or is there something else that you could put on the record?
Can we speak privately, Your Honor?
Why don't you tell me is there anything you can address on the record?
So
you may not, we can go into a Zoom breakout room, but it may not be necessary.
Yeah. I mean, the reason there's a pending motion for summary judgment and defense counsel's here, and I just don't want to. I don't want to speak out of turn on the record. I mean, I'd gladly go back on the record, but if we could speak privately first, I would appreciate that.
Okay, well, let the court ask this. What is the offer?
$13,250, I believe, was the latest offer.
And that was the offer that Mr. Brandenstein made to you, Mr. Tyke, and you mentioned that to your client?
Correct. And in full disclosure, I'm not sure if that offer is still on the table. That offer was made the morning of the defense IME. So I don't know if defense counsel still has that offer on the table or not.
Mr. Brandenstein?
The offer has not been withdrawn. I can tell you that.
So language slightly differently, Mr. Brandenstein, does that mean if the client were to accept that, that would, the court has no idea, but that would still be a valid offer?
That's correct, Your Honor.
Okay, so Mr. Tyke, the offer is still on the table.
Okay.
So is it worth it to communicating that with your client?
My client was aware of that offer and rejected that offer.
Okay, so
Your Honor, I could say this on the record. We've had a disconnect in the value of plaintiff's case. And back in August, when he advised that he was willing and wanting to find a new attorney, that stemmed from my valuation and his valuation. About a week after I sent him a letter advising him about the deadlines that were coming up, he called me and said, he likes us, he trusts us, and he's willing to cooperate and listen to our recommendations. Mr. Brandenstein has made several offers that range from maybe $7,000 up to the $13,000 or $13,250 that is the current offer. And the reason that we're having such a conflict is because in a normal negotiation, I would get his consent to lower our demand. I would convey that to Mr. Brandenstein. He'd give me an offer and I would return that offer to my client. Here, it seems that my client's number changes a lot. So sometimes it's lower, and then other times it's incrementally higher, to the point where it's almost made my job impossible to negotiate a fair resolution for him.
Okay, so what the court would just like to see is whether or not your client might wish to accept it now, or just say that he doesn't want you to represent him. So that's why the court is asking him, because if he accepts it, then the matter is done. It's concluded. If he doesn't accept it, then it might be time for new counsel.
Okay.
So, Mr. Franklin Rodriguez Cruz.
Señor Franklin Rodríguez Cruz, dice el juez.
Okay. Good afternoon, sir.
Buenas tardes, señor.
Buenas tardes.
Buenas, señor.
As you may understand, that this is your attorney's motion to withdraw as an attorney representing you. Do you understand that?
¿Usted entiende que esta vista es para una moción que presentó su abogado para no representarlo más? ¿Usted entiende eso?
Sí.
Yes.
Now, there is an offer on the table from the defense offering $13,250 to settle the matter. We understand that you've already rejected that offer before. Is that correct?
Ahora mismo la defensa está ofreciendo $13,250 y entendemos que a usted se le hizo saber, pero que usted no está aceptando esta cantidad. ¿Eso es de acuerdo?
Sí, pero yo le dije que por lo menos ya por todas las deudas que yo tengo, casualmente ya entre esta semana tengo que pagar 2,500 y pico de dólares para que no me desalojen de la casa.
Let me
Y
interpret, because I'm sorry. Déjame interpretar. Yes, I could not accept that amount because right now I'm in a lot of debt. Right now I have to find $2,500 to pay my rent so I wouldn't be out of my house.
No quiero que me tiren mis hijos a la calle, ya ellos pueden chequear el récord.
I don't
Yeah.
want my family, my children, and myself to be out in the street.
Varias veces ya me han llevado como 4 veces a la corte por pagar tarde porque no he tenido que estar cogiendo dinero prestado.
I have
Resolviendo
I have had to go to court several times because I didn't pay my rent on time. I had to find money, borrow money in order to pay it, in order to stay in my house.
Y le pedí que por favor
Okay, we don't need to go into
a 15.
we
So
don't
he
need to go
requests-
any further into that. The court understands that he will not accept the offer today. The court understands that. And the court appreciates the reasons that Mr. Rodriguez Cruz has mentioned. So could you interpret that for him, please?
Yeah, thank you. So, la corte entiende que usted no aceptó esta oferta y la corte entiende que usted tiene una necesidad económica y que es real. Okay, pero no
So-
terminar.
So as this is your attorney's motion to withdraw, are you in agreement with his motion to remove himself as your attorney in the case?
So, esta vista es para una moción de su abogado para no representarlo más. ¿Usted está bien que se termine esto, con que él termine de representarlo?
No, yo no le pedí eso. Yo simplemente le pedí que por lo menos ya para yo saldar un poco de mi deuda, que por lo menos me lleguen a 15
Okay.
para que terminemos esto.
No, I didn't want him to withdraw from my case and stop representing me. All I want is for him to give me $15,000 at least.
So Mr. Rodriguez Cruz, your attorney's not the bank. He can't just give you $15,000.
So, su abogado no es un banco. Él no puede darle solamente sus $15,000 a lo que usted quiera. No hay que darle.
So if the offer was a number that would wind up giving you $15,000, you could do that. But right now, the offer to settle the case is $13,250. And that's not, Mr. Trike, obviously what he would be receiving, correct?
That is correct, Your Honor.
So you'd be receiving less than that. And you've already told the court that's not good for you.
So, lo que está en juego ahora mismito son la presentación de $13,250. Esa es la oferta. No hay más nada. Y de eso se le deduce los gastos del caso. So, usted va a tener menos de $3,250. Y usted ya dijo que usted no acepta eso, que es muy poco, ¿correcto?
Sí, muy poco.
Yeah.
No, eso no da
Es
ni
que-
para yo mudar a mis hijos. Entonces, de ahí no, De ahí van a sacar, y eso no me queda a mí limpio.
So, exacto, eso fue lo que dije. So, yeah, that's not enough. That's not going to even allow me to find a place to take my kids to.
The court understands that. The court appreciates that and understands that. And the
The court
court's not
entiende eso.
asking, the court, no one's forcing him to take the offer. The court's not doing that. The court was simply asking whether he would accept the offer. He's made, Mr. Rodriguez Cruz, sir, you made it very clear that you don't want to accept the offer. The court understands that. Do you want to explain that?
Yeah. So, señor Rodríguez Cruz, la corte entiende muy bien, muy claro, que usted no está de acuerdo con esta cantidad. La corte entiende que usted tiene una necesidad y por eso esto no es la cantidad. Pero esa no es lo que se le está preguntando en estos momentos.
Okay, so where's the case in terms of the discovery deadlines?
The discovery deadline is passed. We have a pretrial conference coming up later this month. And I believe we're in the January trial pool.
January or December?
I want to say it was I think for some reason I had January on my mind.
If you can just double check, you maybe, well, I don't have the report in front of me, but if you can just double check.
Trial after, so it's not even, it says trial after January 2nd, 2023.
Okay. So, Mr. Rodriguez Cruz, do you understand that? And the pretrial conference, Mr. Tyke, is later on this month?
Correct.
Okay, so, Mr. Rodriguez Cruz, do you understand that the case is really supposed to be tried in January of next year?
Señor Rodríguez Cruz, ¿usted entiende que su caso se supone que vaya a corte en enero del año que viene?
Sí.
Yes.
And Mr. Tyke, do you have is there anything left for you to do in the case other than try it?
Well, we haven't had a settlement conference yet. We haven't had the pretrial conference is obviously is scheduled for December 1st. Aside from preparing for trial and the expert depositions and stuff, nothing discovery wise that's left to be done.
Okay, so Mr. Brandenstein, do you have any objection if the court goes into a breakout room with Mr. Tyke for him to explain confidentially the reason for him to withdraw?
I don't, Your Honor. I just would like to point out there is a motion for summary judgment pending.
Okay, the court appreciates that. So Ben, if you could put in a breakout room, the court and Mr. Tyke.
Judge, you're muted.
Mr. Rodriguez Cruz, what we're going to do is we're going to put you in a breakout room with your attorney and with your interpreter, just to see if
Oh, no. Nos están poniendo en un cuarto aparte con su abogado.
It only gave us 60 seconds.
Sorry about that. When I invited you to the breakout room, it took the judge there automatically, so he wasn't done speaking. Judge, you're muted.
then we're waiting for Mr. Rodriguez Cruz and the interpreter to come back to the room.
Yes, I can't bring her back. She's gonna be back in 30 seconds at the max.
Okay. And Mr. Tyke, Mr. Branson, I want to explain to the interpreter, through Mr. Rodriguez Cruz, through the interpreter, what we're doing. I thought it was best to be first seriously from the court.
3 seconds.
Okay.
2, 1. They should be back.
All right.
Okay.
Okay, we're back.
Okay. So, Mr. Rodriguez Cruz, we're going to put you in a breakout room with your attorney and just see if there's some way we can resolve the case.
So nos van a poner en un cuarto aparte con el abogado para ver si podemos
So
resolver.
that's why. So we'll put you in the three of you will be in a separate breakout room. I will not be able to hear what you're saying. Mr. Brandenstein won't be able to hear what you're saying, and nobody else can. It'll just be the three of you. Do you understand that?
So nadie más va a poder escucharnos ni vernos, ni el juez, ni el otro abogado. Solamente es su abogado y nosotros. ¿Usted entiende eso?
Sí.
Yes.
Okay, thank you. So Ben, if you can put Mr. Tyke and Mr. Rodriguez Cruz and the interpreter in a breakout room together.
Yep, just opened it.
Okay, so Mr. Branstein, I'm not sure how long it's going to take. This is off the record, Danielle. I'm not sure how long it's going to take. So you can go off video, do your other work, whatever you want to do.
Okay, thank you, Your Honor.
I don't want you to take up more of your valuable time just waiting.
Thank you, Your Honor.
A waste of the valuable and precious resources to your clients.
Thank you, Your Honor.
So if there's a way to get you back on, what does my law clerk need to do?
I will just mute myself and
Okay,
stop the video, and I should hear some voices whenever things resume.
that's fine. That's
Thank you, Your
fine.
Honor.
I don't want to interfere with your work. So if you just do that, that's great. All your clients will be very happy.
Thank you, Your Honor.
Okay, thank you. And Danielle, if you can just hold tight, you can obviously do your other work, whatever you need. We'll wait for Mr. Tyke to come out of the breakout room.
Okay, I'll just have myself as well.
Okay, thanks.
And Judge, can I add you to a breakout room? There was something I wanted to discuss off the record.
Absolutely. Absolutely. Let's do it.
Council, are we ready to resume?
Yes.
Okay, I'll let the judge know.
You're muted, Your Honor.
So, Mr. Rodriguez Cruz, did you speak with your attorney?
¿Usted habló con su abogado, señor Rodríguez Cruz?
Sí.
Yes.
And what was the result of speaking with your attorney?
¿Y cuál fue el resultado de haber hablado con su abogado?
Esperar hasta el día de la corte.
To wait until we get to court.
Okay.
Your Honor, just let the record reflect.
And I just asked that the interpreter has to interpret what Mr. Tyke is saying.
Just let the record reflect. Renee Axelrod, a partner at our firm, is in the room as well.
Okay.
And in our conversations with Mr. Franklin Rodriguez Cruz just now, he did advise us that he does not want us to be dismissed as his counsel. I asked that you reconsider my original petition. During the course of his conversation, he did advise that he does not trust us. And he then backpedaled on that comment he made. But this just is par for the course as our attorney-client relationship has been going over the past several months, where it seems to be a constant yo-yo. I would again ask that you please grant our petition to withdraw as counsel, give him as much time as humanly possible to allow him to obtain his own new attorney and proceed to the trial of this case.
So, Mr. Rodriguez Cruz, do you trust your attorney?
Señor Rodríguez Cruz, ¿usted confía en su abogado?
Yo confío en él, por eso tengo casi 3 años luchando con esto.
I trust
Le
him.
damos mi confianza.
That's what I've been with him for at least 3 years because I trust him.
So, when you've told him that you don't trust him, why would you say that?
So, ¿por qué entonces está para atrás como que no está confiando en lo que se está diciendo? ¿Por
No,
qué?
que la cantidad no es razonable, que eso no me da ni para yo mudar mis hijos, que tengo 3 años sin trabajar. No puedo trabajar y necesito mi operación y Eso
The
no
amount
da
of-
para nada.
The amount of money that he has mentioned is not enough. It's not enough for me to find another place for my family. It's not even enough for me to have surgery that I need.
Your Honor, if I may, this is Renee Axelrod. If I may, just for 1 second, if that's
Absolutely.
okay with Your Honor. I came in, I was in the room next door and I sort of heard what was going on. And I know that you asked Jared to speak to the client. So I came in as well. And the client, he wavered back and forth, which I know Jared has indicated he's done during the case, but he actually said to me, I don't trust you guys. So he of course went back on his word later and said, yeah, I trust you. And I want you to try my case. But I tried to talk to him and explain the situation. And he himself, I didn't ask him, do you trust us? Came out and said, I don't trust you guys.
Okay, now the interpreter has to explain everything
Sure.
that was
So I'm
said,
sorry.
has to interpret it.
Sure, I understand.
La abogada, Jared, René, le explicó al juez que cuando estábamos aquí hablando, ella está tratando de explicarte la cantidad de dinero, lo que es el proceso y la situación, y usted simplemente dijo que no está confiando en lo que se está diciendo, que eso no puede ser así, que no puede ser esa cantidad.
De esa
Y no
cantidad
está apreciando, escuchando, aceptando el consejo de su abogado.
no es razonable esa cantidad. Que se
The
ponga ellos en
amount
el
of
lugar.
money is not reasonable.
What's that?
The amount of money is not reasonable. That's all he said.
That's all
Okay.
he's been saying, Your Honor, and he's not listening to any recommendations we make. And he's simply just, he doesn't want to listen to, he doesn't want to hear anything. The attorney-client relationship is really struggling here.
So, Mr. Rodriguez Cruz, I understand that you're not happy with that the money being offered does not meet your needs. You
Señor
can
Cruz,
explain that?
señor Rodríguez Cruz, el juez entiende que usted no está contento con esta cantidad y que usted no piensa que esa es la cantidad adecuada. ¿Ok?
If Mr. Tyke could offer you more money, he would give you that money. Let me rephrase the question. Let me rephrase.
Okay.
Mr. Tyke is simply telling you what the other side is willing to pay.
Su abogado Ty lo que está diciéndole aquí con esto es, esa es la cantidad que el seguro está dispuesto a pagar.
And Mr. Rodriguez Cruz, do you see Mr. Bradenstein here on the screen?
Señor Rodríguez Cruz, ¿usted ve al señor Breinstein aquí en la cara?
Sí.
Yes.
Okay. Mr. Bradenstein represents the other side. Mr. Bradenstein offered the $13,500. Do you understand that?
Señor Breinstein está representando a la compañía aseguradora. El señor Breinstein es quien ofreció $13,000 con 250. ¿Usted entiende eso?
Sí, yo lo entiendo.
Yes, I understand.
Yo lo entiendo, pero él tiene que entender.
Your attorney can't change that amount. If Mr. Bradenstein is saying $13,250, Mr. Tyke then can tell you it's $50,000. Mr. Tyke is simply telling you what Mr. Bradenstein is offering. Do you understand that?
So, su abogado Jared solamente puede decirte lo que el señor Breinstein le dice. Él no puede cambiar la cantidad, él no puede hacer que se crezca, él solamente puede decirle lo que la compañía está dispuesta a pagar. ¿Usted entiende esa parte?
Eso lo entiendo claramente.
Yes, I understand that very clear.
And Mr. Bradenstein's job is obviously representing his client. His job is not to give you whatever money you need for all your needs. That's not his responsibility.
So,
You understand that?
El señor Bradenstein representa el seguro. Él no le importa lo que usted tiene, lo que usted debe, lo que usted quiere. Él solamente representa el seguro. ¿Usted entiende esa parte?
Sí, yo lo entiendo.
Yes, I understand that.
So when Mr. Tyke told you the offer was $13,250, he was telling you what Mr. Bradenstein said. And Mr. Tyke, you're recommending that that your client take that money, correct? Or you recommended that?
Not exactly. I was recommending that he allow me to try to negotiate a higher amount than that, but in full transparency, I don't see the amount being as high as Mr. Franklin's expectations and desires are.
Okay. Mr. Rodriguez Cruz, do you understand that?
Señor Rodríguez Cruz, ¿usted entiende eso?
Sí.
Okay.
Yes.
Now, obviously, Mr. Rodriguez Cruz, nobody forces you to take an offer.
So, por supuesto, señor Rodríguez Cruz, que nadie le puede obligar a que acepte una oferta.
Claro, es que no es
Of course.
razonable. Él lo piensa y para él mismo en su conciencia no va a estar bien de lo que está ofreciendo. ¿Qué voy a hacer con $2,000? Donde a mí ya me están sacando de mi casa, mis hijos. Oye, lo que yo pago de gente y todo el lío que tengo, no me da ni para...
He's talking about, he's saying that if he believed that, he would not even look at him because that is not a fair amount. That will not allow me to pay my rent. He showed the piece of paper or receipt that he owed. That is not a fair amount, he continued to say.
Si no pago
So,
mañana, me van a tirar
If I don't
so
pay
Mr.
tomorrow,
Rodriguez Cruz, are you saying because Mr. Tyke told you that amount that you don't trust him?
so usted está diciendo que porque el señor Tai solamente le está diciendo que puede solamente tomar este dinero, usted entonces no confía en eso, que eso es lo que está diciendo usted.
No, eso no es razonable, no.
No, that is not reasonable.
Okay, so because Mr. Tyke told you a number that Mr. Brandenstein said, do you not trust Mr. Tyke?
So, porque lo que te está diciendo de 13,250 es lo que más puede conseguirte a él, del seguro. ¿Usted no confía en eso? ¿Usted no cree eso?
Pero si fuera 13,000 nada más para yo resolver mi problema, pero ¿qué me va a quedar a mí? Nada.
So
Eso
if it would have been,
no como nada.
if it would have been $13,000 that I get to keep for me, okay. But with that, I cannot do it. It doesn't help me with anything.
That's not what I'm asking. And by the way, I'm sorry, is it Mr. Tyke or Mr. Titch?
It's Teich, but it's okay. Your Honor.
Tyche. Okay, thank you. So the court, I understand that you don't want that amount. That doesn't meet your needs. What I'm asking, Mr. Rodriguez Cruz, is are you saying that because that amount is too low for you, that you don't trust Mr. Teich?
Eso no es lo que le estaba preguntando. Lo que él quiere que usted diga es el hecho de que su abogado, el abogado Teich, le dijo a usted que la cantidad que el señor Branson le dijo a él, que está en la mesa es 13,250. Como usted piensa que eso no es suficiente, entonces usted no confía en el abogado Teich.
En el abogado, está bien que yo ofrezca eso, pero él sabe que no es una cantidad razonable.
My attorney should know that that is not a reasonable amount.
Well, your attorney knows that. But because
Su abogado sí entiende eso.
Sí, yo lo entiendo.
because your attorney
Pero no hay más
mentioned that,
nada.
or you saying you don't trust him?
So, por el hecho de que no es la cantidad que usted quiere, aunque él está diciendo que es la cantidad que el seguro está ofreciendo, usted quiere decir que entonces usted no cree que lo que le está diciendo a usted, él no es verdad. No confía en
Él me
eso.
está diciendo que es verdad, pero que no es suficiente para el problema que yo tengo, ni para mi operación, nada. Para nada, no me da para nada.
I understand
3
that.
años sin trabajar, sin poder trabajar.
I understand.
¿Qué hago yo con eso?
I understand that and believe that the amount that my attorney said is the amount that the insurance is saying, but that is not enough money. I have to pay bills and that is not enough. I cannot settle for that.
Okay.
Your Honor, can you ask him if he trusts my recommendations?
I think that we need more of an explanation. What do you mean by do you trust his recommendations?
I mean,
I don't know what that means.
Like,
I don't know how I,
yeah,
I
I
don't know
mean,
what that
my
means.
recommendations on negotiating a fair settlement for him. I guess, I don't know, I'm
but you
trying.
haven't recommended it. You haven't recommended that number.
I have not, but I've recommended other numbers and he has not been interested in those numbers either.
So are you saying, was the court still not sure what you're asking the court to say? Because the issue is, does he trust your recommendations?
Yeah.
You're parsing it with quite a nuance.
Yeah. I mean, a moment ago,
someone-
he just said he didn't trust us. Again, we're going
Because-
through an interpreter.
Someone could trust that you're giving your best recommendation and they can still not like it and won't accept it.
I agree with you, Your Honor. I'm not sure
That-
we're making much headway here.
There's like no progress. The court appreciates it, but it is what it is. He's been with you 3 years. That's what he says.
I don't know if that's
with
100%
substantial
accurate.
amount of. I don't think that's accurate either, but he's been with you a period of time.
He has, and
So-
he's been with us for 2 years. And
Okay.
and I always wanted to help him out and do the best by him, but in my most recent conversations with him, I truly believe that this relationship has soured and that there's no way we'll have a meeting of the minds where we'll ever be on the same page. And I again ask that you grant our petition to withdraw and allow him.
Okay, the court appreciates it because you're so close to trial. Discovery's all complete. You're facing a pretrial conference soon and an imminent trial in the beginning of the year. The court's going to deny the motion to withdraw.
Would the court
Obviously,
grant
if there's
an
something
oral
else that
motion to-
occurred,
Would the court grant an oral motion to remand this case to arbitration now, or do I have to file something?
Client has authorized a remand to ARB.
The client, we discussed it at our last breakout room, and he agreed to it.
okay, so the interpreter has to interpret that.
Okay.
So,
Nothing the court can do without the interpreter interpreting all that.
okay, so, su abogado le preguntó al juez que si podemos entonces ir a arbitración más pronto y que hablamos usted con nosotros aquí y que usted estuvo de acuerdo que sí, que tú querías que ya esto se decidiera ya, que se podíamos ir a arbitración, que hiciéramos eso ya. ¿Eso es
Sí.
cierto?
Sí,
Yes, I agree.
arbitración es ir a la corte.
So arbitration means go to court, have a hearing?
So are you, Mr. Rodriguez Cruz, are you agreeing that the court doesn't even know if he understands what compulsory arbitration is?
We explained it to him during our last breakout, but
Okay.
I agree with you.
explained it to
I'm not 100% sure if I've explained it to him several times, so I'm not quite sure what his mindset is,
Well-
to be completely honest.
Well, counsel still needs, the court can orally just put it in compulsory arb. There could be a stipulation that both sides sign, and then the court can do that.
Okay.
Or because the court receives a lot of stipulations, or counsel can file a motion. Stipulations are much easier, but the court needs something before it puts it into compulsory arb.
Well, I could talk to Mr. Brandenstein after the hearing and see if he'd be agreeable to it.
Okay. And Mr. Brandenstein, you wouldn't object to it, would you?
He's
You're
muted.
on mute.
Sorry about that, Your Honor. I don't believe that we would object, but I need to speak with my client just to confirm.
Okay, so if you can do that, the court will deny the motion to withdraw, and the court looks forward to receiving a stipulation from both counsel that the matter is transferred to that both counsel want the matter transferred to compulsory arb. The court understands that Mr. Brandenstein needs to talk to his client to confirm whether or not that's the case. Obviously, if the client is opposed to it, that doesn't happen too often from the defense, but it might be the first that this court has seen. But if the defense wants to go to a major jury with all the risk, then the court will not be seeing a stipulation.
Understood, Your Honor. I just need to confirm it.
The court understands. So anyway, the court has ruled And if the interpreter can explain that, what the court just said to Mr. Rodriguez Cruz.
So, el señor Rodríguez dice, el juez, que no le autorizó a su abogado a que saliera del caso, pero sí estuvieron de acuerdo los dos en que hicieran una petición para ir a arbitración. So, si ellos están de acuerdo, vamos entonces a tener una fecha que nos van a dar para entonces estar haciendo la arbitración.
Okay.
Okay.
Okay, so the court will draft an order denying the motion to withdraw, and the court looks forward to the stipulation from both counsel. So everyone have a good day. Thank you very much for all your time and effort. And the court looks forward to seeing you all with the next case. Anyway,
Your
thank
Honor.
you all. Take care. Have a
Thank
good
you,
rest
Your
of your day.
Honor.
Thank you, Your Honor.
Okay.
Everyone's excused.
Thank you.
Danielle, thank you very much.
Judge, I'll be
Thank
down
you,
to the
Judge.
courtroom momentarily.
And Ben, if you'll draft the order
Yep.
denying the motion to withdraw.